Welcome everyone. This is class number 18 of the July 2023 Ibis Prep MBE crash course. We're joined today by Professor Matt Beckerman. We want total participation, everyone to be, curious and asking points, and we'll get through it because evidence questions are super short. We're going to get through 25. We're going to have the polling feature, and this is just going to be a super smooth class. So I'm just going to jump right into Adaptabar. We will pull up 25 evidence questions and roll the dice. So I'll read the first question. Let me pull up the polling feature, if I may, and we'll get started. Everyone can see the poll? Oh wait, you can't answer that poll, sorry. Technical difficulties. Everyone can see the poll? Sweet. All right, a plaintiff sued a defendant for assault after a late night barroom brawl. At trial, the plaintiff planned to call several bar patrons who had been present on the night in question to testify to the circumstances of the alleged assault. The trial judge ordered all witnesses excluded from the courtroom during the trial except for the parties. The trial judge then ordered the plaintiff to testify first during his case in chief and to relate his version of events before hearing the testimony of other eyewitnesses. The plaintiff has objected to the order requiring him to testify first. Did the trial judge exceed her authority in ordering the plaintiff to testify first? No, because the trial judge has broad discretion to exercise control over the order of examining witnesses. No, because the trial judge must determine the order in which evidence is presented at trial. Yes, because a party is always permitted to control the presentation of proof during his chief and case. Yes, because the defendant did not demonstrate likely prejudice from permitting the plaintiff to present evidence in any order he wished. So the results are coming in. Everyone take a moment. Thank you, Grace, for saying you could see. So we have 66% participation, 70% participation. We can get one more vote. Let's launch the results. Excellent, everyone. So everyone picked A for the most part. I agree with A, that the trial court does have broad discretion over the order of examining witnesses. For the bar exam, and I'm not a trial attorney, so don't tell me in real life. I'm just telling you on the bar exam, this is how I envision it. The judge is the king of the court. He's like the commissioner of the league. If it was the MBA, he's the commissioner. He's not the, ref making the jury decisions, or he's not the coaches, or the players. He's just the one, or she's just the one overseeing it all. Now, also by that same token, the clerk is like the doorman, the person who walks you to your seat. I'm not trying to, make light of anyone who is a clerk in here. I think it's an amazing job. But I'm just saying on the bar exam, the clerk can't really do much. So if you ever see a question where it's like, oh, the clerk told him this, be wary of what the clerk can do. The clerk can, notate a default and enter it only if it's a sum certain and there's been no activity on the case. But that's like a very rare occasion. Usually the clerk can do nothing. In this scenario, imagine the judge. Yeah, he has broad discretion over the order of examining witnesses. So I do want to pull up our cram guide just to make sure that this gets added. But the judge has broad discretion over the order in which to examine witnesses. That's interesting. Everyone can see that our cram guide is growing, and a growing cram guide is like a growing child. It's a thing super. So today's date, 25th, 7/25. It's like Christmas in June, and we're doing evidence. And the first point of law is that the trial judge has broad discretion over the order of examining witnesses. Fair enough? All right, let us proceed. I'm gonna stop sharing, launch the next poll, turning into a master of this. A defendant is on trial for the murder of his father. The defendant's defense is that he shot his father accidentally. The prosecutor calls a witness, a police officer, to testify that on 2 occasions in the year prior to this incident, he had been called to the defendant's home because of complaints of loud arguments between the defendant and his father. and found it necessary to stop the defendant from beating his father. The evidence is inadmissible because it's improper character evidence. Inadmissible because the witness lacks firsthand knowledge of who started the quarrels. Admissible to show that the defendant killed his father intentionally. Admissible to show that the defendant is a violent person. This question makes me think of Marvin Gaye. His father shot him after a quarrel. One of the great artists of our time.
I think that was, or no, his father shot him.
Yeah, that's what I said.
Oh, yeah. But I think that was more accidental. At least I hope so.
How do you know you weren't there?
No.
I'm just messing with you. You probably know more. You probably actually, I read the excerpts of all the cases. All right, we got 70% participation. One more vote. One more vote. One more vote. There we go. All right, we have a split. Wow, we're gonna have to bring up a delegation. Can everyone see? Would anyone like to argue for the A delegation? A has more votes.
Isn't it because it's prior bad acts that wasn't conviction or something?
Oh, that prior bad acts. I'm going to throw my vote into C and make it 9 out of 20 for C. What do you think, Matt?
Yeah, I voted C. I think it's like admissible as a mimic.
Yeah, I think it's a mimic too. It's a
lack of mistake.
Yeah, or just intent, like
Yeah,
not to show that you did it, but to show that if you did do it, it was intentional because you and your pops were quarreling. Bruh, no, can't not sing. I was just doing some Marvin Gaye. Keep it light. All right. The answer is C. Evidence of prior fights and beatings is admissible for the purpose of establishing the defendant's intent or absence of mistake. We're both right. Given that his defense is that he's unintentionally shot his father. What's up, Scarlett? Hands up.
Yeah, I have a question. So with the axe and like the mimic, isn't it also just to make sure that it's not to prove a specific element of that crime or case?
Yeah, literally anything
saying
except
that he shot his father.
Yeah, because
And
like I could
not-
see, but I wasn't sure because like I kind of I was thinking it was C2, but I was not sure. I was like double guessing myself between A and C. And the reason I was double guessing myself was because I thought it was not allowed in if it was going to prove like an element of a crime.
So no, it can prove an element. So he's like, so it can't be used to say he shot his father, but the son already admitted that he shot the father. He's saying I did it accidentally. This is being used to cast doubt on the accidental part, not to show anything that he shot his father. Which
More like rebut a defense.
So it's like it would probably I mean, like normally they'd use a limiting instruction, but here like he already admitted to shooting the father, so probably not.
Okay, perfect. Thank you, Matt.
Yeah.
all right. Vamos a la playa. Too long. I hate that question. It bores me. This one. In the prosecution of a defendant for forgery, the defense objects to the testimony of a government expert on the ground of inadequate qualifications. The government seeks to introduce a letter from the expert's former criminology professor stating that the expert is generally acknowledged in his field and well qualified. On the issue of the expert's qualification, the letter may be considered by the jury without regard to the hearsay rule, the judge without regard to the hearsay rule, neither the judge nor the jury because it's hearsay not with any exception, both the judge and the jury because the letter is not offered for a hearsay purpose. This question right here, if you're in my class, you're an Ibis bar prep student, is a slam dunk on the exam. I don't care if you don't know it now. On test day, after this discussion, it will be known. So everyone's nervous. It doesn't matter, your answers are anonymous. But this question or type of question will be known, and it's going to be reinforced by what we learned on the first question, if that gives anyone a hint. Any one of the remainders. Let's see. One more vote, please. One more vote. All right, thank you. Whoever cast that last second vote, you're a real one. So the answer is indeed B. right? Remember, the judge is like the commissioner. What's up?
We haven't seen the poll results.
Oh, my bad. I'm sorry. Thank you, Matt. Now you see. The answer is indeed B, because the judge is the master of the court. He's the gatekeeper. She's the gatekeeper. She lets in evidence to be weighed by the jury, or she doesn't. So she's the one who determines whether it's hearsay or not, and these things. Admissibility is a question for the judge. Credibility is a question of weight for the jury. So let's go with the judge. That's who will determine the admissibility of it. Admissibility is a question for the judge, and the judge may consider without regard to the hearsay rule. The judge may literally consider anything, right? The judges seen it all. They're not going to be, they're not the ones deciding the case. We're all good with B? So the explanation is preliminary questions of admissibility are for the court. Realize when they say the judge and the court, it's kind of the same thing. That means the same thing. The judge / court determines questions of admissibility and may consider evidence that may otherwise be inadmissible, such as hearsay. So, if there's an objection to the evidence, it's reviewed under the abuse of discretion standard. Okay. Yeah, just flexing off our knowledge of abuse of discretion standards. Okay. Let me pull up another.
This is a short question.
I know I love short questions. They're my favorite type.
Oh, it's long. Never mind.
See, man, you got tricked. A plaintiff has sued a defendant alleging that she was run over by a speeding car driven by the defendant. The plaintiff was unconscious after her injury and, accompanied by her husband, was brought to the hospital in an ambulance. At the trial, the plaintiff calls an emergency room physician to testify that when the physician asked the plaintiff's husband if he knew what happened, the husband, who was upset, replied, "I saw my wife get run over 2 hours ago by a driver who went through the intersection without looking." Is the physician's testimony about the husband's statement admissible? No, because it relates to an opinion. No, because it's hearsay without any exception. Yes, as a statement made for the purpose of diagnosis or treatment. Yes, as an excited utterance. Tough question. I see an even split coming already. All right, we have 70%. There we go. Perfect. So we have a majority B, minority C. Anyone want to argue for the B delegation?
He's not super excited. And this isn't really helping the medical treatment.
Go ahead, Scarlett.
I was gonna say, yeah, like I was gonna, when I was deciding between B or C, I ended up going with C just because I didn't see an exclamation mark, which was something that, even though it said it was upset, I just didn't think it was an excited utterance. Also, like, the facts don't really say that he says, it says that she was accompanied by her husband, but isn't really quite say if he actually witnessed it. But maybe that's just the way I read it. I don't know. But I pick C.
Okay. Anyone else pick C or pick B?
I picked B, but I thought it was more like a hearsay within hearsay because you have the wife, she's unconscious, and she's the one suing, and then you have the husband, and then you also have the doctor. So he's trying to relay whatever the doctor told him. So, and then she's trying to bring it in. So that's why I picked B.
Yeah, I picked B also, and I kind of also just did process of elimination, but also hearsay within hearsay.
What do you think, Matt? What was your thought?
Yeah, I picked B.
Yeah, it seems like hearsay to me too. I mean, and you were saying this doesn't really seem like it's for the purpose of medical diagnosis.
It's not.
It's not. Yeah, I tend to agree. There you go. I like the confidence. Like it is not. The physician's testimony contains an out-of-court statement by the husband that is being offered for the truth of the matter asserted, what happened in the accident, including who was at fault. The statement is not for the purposes of medical diagnosis or treatment, but to establish liability, right? It was saying like he went through the accident. Moreover, it was made 2 hours after the accident. Therefore, it's not excited utterance because the excitement of the event has likely passed. Let's see. Hearsay is something offered into evidence in order to prove the truth of the matter asserted. Out-of-court statement, proffered in evidence, or truth of the matter asserted. A statement that describes a person's medical history or their inception or general cause is admissible as exception to the hearsay rule if it was made and when reasonably pertinent to medical diagnosis or treatment. The cause of the source of injury must be reasonably pertinent to diagnosis or treatment to be admissible, and statements assigning fault or identifying a perpetrator are generally not considered pertinent, right? That's exactly what Matt said. This was not for medical diagnosis or treatment. This was a statement assigning fault or identifying a perpetrator. Statements by family members or bystanders may be admitted under this exception as long as they're clearly made to obtain or diagnose a treatment for the patient. So some of the other students were mentioning that maybe hearsay within hearsay, but it could have been admissible if it was for medical diagnosis. What Matt was saying was really what they were getting at. The statement was out of court being offered a truth of matter asserted. What happened in the accident, including who was at fault, because the statement was made to establish the defendant's liability for the accident, it was not for the purpose of diagnosis or treatment, right? You really said it was Tommy went through the accident. It wasn't like Martha's elbow was bleeding. The statement was also made 2 hours after, so it was very unlikely that it was continuous excitement, so it was not excited utterance. Let's see what we have in the chat. Some questions. I understand. Light bulb. Nice. I like light bulbs. And Iona, did you have your hand up?
No, you answered my question. Thank you.
All right, nice. I mean, to be fair, I just read their answer, so. But your question was answered is better phrase. All right, so what do we learn from this? That statements made for assigning liability are not made for the purposes of obtaining medical treatment and thus are hearsay. Is that fair enough? I think so. Stop sharing. Launch the next poll. Getting super good at this. Someone sent me into Wheel of Fortune. I'm good at spinning wheels too. Very good at spinning wheels. All right. A cyclist sued a defendant corporation for injuries sustained when she was hit by. No, I can't stop having this. I'm sorry. A cyclist sued a defendant corporation for injuries sustained when she was hit by a truck owned by the defendant and driven by its employee, who was making deliveries for the defendant. The day after the accident, the employee visited the cyclist in the hospital and said, "I'm sorry for what I did." At trial, the employee has testified that he exercised due care. Why is a cyclist's testimony relating to the defendant's employee said at the hospital admissible to prove negligence? Oh, so they just told you it's coming in. Is it a prior inconsistent statement? Is it a statement against interest? And someone better be able to explain the difference between these two when I call on them. Is it a statement by a party opponent's agent, or is it a statement of then existing state of mind? Take a minute. We got a lot of answers. And I thought this one was going to say it's a admission, which would have meant I was like, explain the difference. And just so we understand, party opponent admission and statement against interest, statement against interest requires unavailability. That's the key piece to that. But that's not really what this question is testing, now that I look at it. Someone, no, Scarlett, your vote is anonymous. Just in your own mind, you can and get it right. But everything is final. These are final judgments, no appeal, no interlocutory review. Can I get one more vote? Can I get a vote? Thank you. Okay. We shall share the results. And I think this is actually a party opponent admission, right? And it's by an agent. So I was actually saying, what's the difference between B and C? Statements against interest, they have to be unavailable. Party opponent admission is when they are available. And here everyone's saying it's an agent of the party opponent. Why is it an agent? Because it's an employee of the defendant corporation. Are you rocking with C, Matt? Yeah.
Yes.
So an employee statement to be substantially admissible is non-hearsay admission by an agent of party opponent because it's regarding a matter within the scope of employment during the existence of employment relationship. So a party opponent admission is admissible if made by an employee within the scope of employment. The scope of employment. Duties, I guess. As an, what do they call it? Agent. As an agent of, let's say, a corporation. Or let's just say an employee. Everyone saw the results here? Yeah. Any questions about that one? Ready to launch the next poll? Okay. A defendant was charged with murder. While walking down the hallway during a recess in the defendant's trial, the judge overheard the defendant say to his attorney, "So what if I did it? There's not enough proof to convict." After the judge reported the incident to counsel, the prosecutor called the judge as a witness in the trial. Is the judge's testimony regarding the defendant's statement admissible? Yes, as a statement of a party opponent. Yes, because the defendant's statement, although otherwise privileged, was made without reasonable efforts to preserve confidentiality. No, because the statement was privileged attorney-client communication. No, because a judge may never testify in a trial with which he or she is presiding. I'm actually going to have to end. Ooh, never mind. I was going to say I'm going to end this poll because we have unanimity.
Yeah, everyone has to get this right.
No, don't say that because someone already didn't.
Oh.
You don't want to be bullies. As someone who has a dog that's been subject to bullying by being a bully, no bullying.
But everyone will get this right on the test.
Exactly. That's the way we believe. Everyone will get this right in the test. Remember, we talked a lot about the judge. She's a very powerful woman, this judge. She can control the order of presentation. She can decide whether evidence is admissible or not, and it could be hearsay. She gets to consider anything. And she may not ever testify in trial over which she's presiding, right? We gotta give her some limitation. She can't. Think about this. What's his name? Adam Silver. He's the commissioner of the MBE. He can't play in a game, you know? He can't referee a game. He can't, go in there and be like, oh, I think it was a foul, right? That's kind of what this answer is getting at. A judge may never testify in a trial over which he or she is presiding. A judge may never testify in a trial in which she...
Yeah, that'd just be crazy.
What'd you say? That'd be crazy?
It would be crazy.
It'd be crazy. We got Nicole. Welcome to the show. All right, smoothing. I was about to say smoothing along, but I was saying like moving along smoothly. I just combined that, smoothing along. Yeah, this is a longer question, but I like Crazy Fool. I'm interested in what this Crazy Fool did. A college student, also. Those go hand in hand. These could be synonyms. A college student sued an amusement company for injuries he sustained when the amusement company's roller coaster allegedly malfunctioned, so the student fell out. At trial, after the student presented his case, the amusement company called a witness who testified that just before the accident, he heard a bystander say to the bystander's companion, "That crazy fool is standing up in the car." The student has offered the testimony of another witness who would testify that the day after the accident, she was with the same bystander, and that in describing the accident, the bystander told her that the car had jerked suddenly and just threw the guy out of his seat. Those seem interesting. How should the court rule with respect to the offered testimony? Ruled admissible only to impeach the bystander's credibility, ruled admissible to impeach the bystander's credibility and to prove the amusement company's negligence, ruled inadmissible because the bystander was given no opportunity to deny or explain her apparent inconsistent statement, and ruled admissible because the bystander herself was not called as a witness. Ooh, my timing was so good there at loading the poll. So what's up? We're bringing this in for impeachment purposes. We're bringing this in for credibility purposes. Or we're not bringing it in at all. I've come to like evidence. I didn't used to. It's acquired taste. Evidence questions, they get better with time. Let's see. Oh, 77% participation. That's amazing. Participation is at an all-time high. So most people went with A. Iona, raise your hand. What's up, Iona?
I have a generalized question, not specific to the facts of this question, but more of the structure. I've seen a number of evidence questions that ask if evidence is coming for impeachment or substantive. And I always I understand the impeachment part, but I always get confused with the substantive part. Can you clarify that, what that is meant when it's asking, in addition to impeachment, if evidence is also coming in substantively?
So if
I
it,
could put it generally, but yeah, Matt, why don't you go ahead?
so it can be used for impeachment if it's like if it goes against what the person previously said. It can be used substantively if it satisfies like the hearsay requirements.
Okay, so that's what it's meant. It's that it also meets a hearsay exception or non-hearsay requirement.
Would you agree with that, Andrew?
Well, not just that it's really the hearsay, substantively mean like it can be used as related to the case. Like
Right. Yeah. But like in order for that to happen, it would need to like meet a hearsay.
It would also need to be relevant. It would also need to pass the 403B balancing test. Like there's a whole bunch of
Yeah,
factors.
but I mean, in this case, it would be, except for the.
No, but she's saying in general, what is the word?
Okay. Yeah. In general, yeah.
What would you say, Matt, in general? What does that word mean? That this evidence can come in for substantive purposes? If you explain this to a 10th grader.
It needs to be relevant, not unduly prejudicial.
That's how you explain it to a 10th grader? No, but
To a 10th grader.
what does that mean? Like it's substantive. It's not just for impeachment. It's also available to come in for substantive purposes. What does that generally mean?
You can use it to prove your case.
Period. Right? You could use it to prove your case. That's what that means, Iona. Like impeachment is to impeach a witness. Substantive is to prove the case. I love that boiled down definition. So here, everyone's saying it's only admissible for impeachment. We're not going to bring this statement in to show that, you know, the thing malfunctioned and he caused injuries, but we're potentially going to bring it in to show that the person who said that he's standing up in his car, he also said that it suddenly jerked and threw the guy out of his seat. So like those things kind of conflict with each other. Yeah. Okay. What do we think the answer is?
So I put A.
Yeah, I put A too. People are just
Matt, if it's not hearsay or if it's admissible as a hearsay exception, that also proves that it's substantive.
I always think of this one as the red light, yellow light example. This is an inconsistent statement, right? Andrew said that the light was red. Now someone's bringing in evidence that Andrew also said the light was yellow. Well, we're going to bring in that evidence that Andrew said the light was yellow, that inconsistent statement, not to show the color of the light, but to show that Andrew is not very credible, right? That's what this is doing right here. We're not bringing it in to show that it just threw the guy out of his seat. We're bringing it in to show that this dude is saying conflicting things. Therefore, he's not really reliable. We're rocking with A. I agree too. So regarding the second statement, is admissible to impeach the witness's statement regarding the bystander's previous statement, which suggested he was standing. If introduced as substantive evidence, that would be inadmissible because there's no applicable hearsay exception allowing the bystander's later statement to be admitted. That's what Matt was literally saying. Like in this specific example, there's no hearsay exception. Exactly what you guys are all saying in the chat. Let's see. In this case, when the amusement company called the first witness, the bystander was a hearsay declarant whose statement was likely admitted as an excited utterance or present sense impression. For that reason, the first witness can testify to the out-of-court statement. That crazy fool is standing up in the car. The student's later witness looking to testify to the bystander's second statement from the following day that the ride just threw the guy out of the seat, however, would be inadmissible hearsay. No hearsay exception applies to the later statement by bystander that would allow it to be admitted substantively. The statement is admissible as a prior inconsistent statement to impeach the bystander, however. That's what I was trying to get at. These definitions are long-winded. It contradicts the bystander's earlier statement, which suggests that the student was entirely at fault by standing up in the car. FREO 6 provides that hearsay's declarant's credibility may be attacked by any evidence that would be admissible if the declarant had testified as a witness. So what I take from this one is a witness may be impeached by a prior inconsistent statement, but the statement cannot come in for substantive purposes unless it meets all requirements,
Yeah.
including hearsay, except including that it is not hearsay. Like, this is clearly hearsay. Someone just said that this happened. Like, what do you mean? That's not very reliable. All right. I was just joking now when I said that's how you explain it to a 10th grader. No, it's all good, guys.
I think a 10th grader can understand that.
Yeah, I mean, I was pretty smart as a 10th grader. I think 10th grade was like peak of my mental capacity. That's why I was studying for the SAT, which I teach for the GRE now. The SAT is literally harder than the GRE. If anyone wants to take the GRE, let's get to work. All right. At trial, an action for, oh, everyone wants the poll to be launched. In trial, an action for personal injuries suffered in a traffic accident, the plaintiff first calls the defendant as an adverse party. The plaintiff then calls a witness who was a passenger in the plaintiff's car, but who also happens to be the defendant's former employer. On direct examination, the witness testifies to how the accident occurred and also expresses his opinion that the defendant is not a truthful person. Which one of the following areas of questioning is most likely to be held beyond the proper scope of cross-examination? In letters to prospective employers, the witness has described the defendant as very honest and dependable. The defendant recently filed an action against the witness for breach of contract. The plaintiff's injuries were not as serious as the plaintiff is claiming. The witness has been falsifying his income tax returns. Very tough question. Don't answer it quickly. Very hard question. I did this question this morning and I told the student it was a very hard question. And then I told him that when we did it live, if we saw it on camera, I was going to pretend that it was an easy question and that I knew it easily. But I'm just too honest. Honestly, can't lie. This question is hard. My plan of pretending it was easy did not come to fruition. Yeah. The straw man has revealed himself. Okay. All right, let's see what the answer is. We have a super even split. I know what the answer is, so I want to see what anyone thinks. I mean, we could start with you, Matt. Do you have a thought?
I think it is C, because C is the odd man out.
Let's hear it. Instead of hearing everyone explain it wrongly, let's hear Matt explain it.
I wasn't completely sure, so I did more like
wanna hear it.
process of elimination. So a cross-examination, like it can only be the subjects that were on direct examination or to impeach. So by one I mean A, in letters to prospective employers, the witness has described the defendant as very honest and dependable. On direct, the witness said the defendant is not a truthful person. That's inconsistent. That they can be used for bias purposes. B, the defendant recently filed an action against the witness, ulterior motives. D, the witness has been falsifying his income tax returns, truthfulness. So the plaintiff's injuries were not as serious as the plaintiff is claiming. That's not really what the witness, that's not really within the scope of like the direct examination.
No, right. These are all related to the truthfulness of it, right? And this one really isn't. It's related to the seriousness of the injury of the plaintiff, not even of the defendant. These are talking about the defendant, and this is talking about the truthfulness of the witness. This one's talking about the plaintiff's injury. Why is that something to be talked about? And know that it sounds simple when Matt explains it and then I reaffirm it. It is a very, very difficult question from the outside looking in. Does anyone have any questions about why the answer they chose is incorrect? Nice. Silence. See that, Matt? Mic drop. You just explained it so perfectly. You silenced the crowd. C is correct. The area does not fall within either scope of material. Either the scope of material covered on direct exam of the witness or the witness's credibility, and as such is most likely to be held beyond the proper scope of cross-exam. So the key here is that cross-exam is the scope of the material covered or the credibility of the witness, right? So scope of cross-exam is limited to material on direct and credibility of the witness. That's why on this one, asking into the plaintiff's damages is not really something that had anything to do with their expertise. Now the poll is launched. You guys give me a tough time. I'm not here. Oh, here, perfect. Short question. In a federal civil trial, the plaintiff wishes to establish that in a state court, the defendant has been convicted of fraud, a fact that the defendant denies. Which mode of proof of the conviction is least likely to be permitted? A certified copy of the judgment of conviction offered as a self-authenticating document, testimony of the plaintiff who was present at the time of the sentence, testimony by a witness to whom the defendant made an oral admission that he had been convicted, judicial notice of the conviction based on the court's telephone call to the clerk of the state court whom the judge knows personally. If anyone listened to me, what I said about the people in the court, the answers are coming in right. I think I hit home. The clerk is the doorman. He's the one who takes you to your seat and asks you if you want your lemonade. He's not the one who's telling people, what's going on, right? We agree, Matt? You think it's D, as in the clerk?
Yeah, because D kind of bleeds into the judge being like part of the case.
Yeah, it's all bad news. These things, a certified copy is probably coming in. Testimony who was present by the plaintiff who was present, that's probably coming in. And a witness who we made admission to, probably coming in. This right here, based on the doorman. You're a doorman.
Also, that's not how judicial notice works.
Yeah, exactly. I don't know what that's from. You're a doorman.
The judicial notice is only for things that aren't subject to reasonable dispute and like that people generally know. This is more of a specific fact that would have to be proved.
It's not generally known in the community or cable. So
judicial notice is like Tallahassee is the capital of Florida. Like that's a judicial notice fact. Though I guess not everyone knows that.
Information acquired by a judge via a phone call from the clerk is not judicial notice, not something. Let's just say not judicial notice. Cannot be considered judicial notice. Considered judicial notice. And I apologize to all people out there who are doormen. I think that is actually a really great career, and you're opening doors for people. Literally, that's what I do. That's what Matt and I do. We are literally doormen, so nothing personal. Being a doorman is awesome. Doorman. Let's check it out. I love evidence questions, they're so short. At defendant's murder trial, the defendant calls his first witness to testify that the defendant has a reputation in a community as a peaceable and truthful person. The prosecutor objects on the ground that the witness's testimony would constitute improper character evidence. So it's murder. The court should admit the testimony as to peaceableness, but exclude the testimony as to truthfulness. Admit the testimony as to truthfulness, but exclude the testimony as to peaceableness. Admit the testimony as to both character traits. Exclude the testimony as to both character traits. Okay. I just had to check to see if people were here because it's so quiet. Like, I like the polls, but class is quiet. I should make a poll to decide if people like the polls or not. Do you guys like the polls? All right, cool. Gabby just was the representative of the class. And she had all the elements: commonality, adequacy, numerosity, typicality.
I think the polls are good, except when everyone gets the same answer, then it's not as useful.
Yeah, but all right, here we go. The poll. The claw. Yeah, we're not bringing in truthfulness. This is murder. You could be a liar, but who cares? Your murder is peacefulness is what's important here.
Truthfulness can just be in response to something. Always.
People just love technology.
Unless it's like an element of the crime, then I assume you could bring it in. Yeah. Unless like falsity is an element of the crime, truthfulness always has to be brought in response to something.
So we'll say only reputation of a person's character that is relevant to the crime can be brought in. For instance,
actually, I'm gonna stick with truthfulness always has to be in response to something.
For instance, in trial for murder, only can bring in evidence of peacefulness, not truthfulness.
And I think only in a criminal case, like in a civil case for like wrongful death, I don't think you can bring in peacefulness unless like someone opens the door. But I can double check.
A plaintiff sues a defendant for breach of a promise letter allegedly written by the defendant to the plaintiff. The defendant denies writing the letter. Which of the following would not be sufficient basis for admitting the letter into evidence? Testimony by the plaintiff that she is familiar with the defendant's signature and recognized on the letter. Comparison by a trier of fact to the letter with an admitted signature of the defendant. Opinion testimony of a non-expert witness based upon a familiarity acquired in order to authenticate the signature. Evidence that the letter was written in response to one written by the plaintiff defendant. Also, if you're in my course, you have to get this question right on test day. It's actually a fundamental requirement. I seriously got distracted, Shelby, by whatever you were drinking. I was like, what is that? What? And then I was like, wait, I'm reading your question. What is it that you're drinking?
It's a protein drink.
Okay. Yeah, I was like, that's a weird looking. Doesn't look like watermelon juice. That's an inside joke from Shelby when we used to work on the LSAT. At the time, I was addicted to watermelon juice. It's a healthy addiction. All right. Did you vote this one, Shelby? You sent it in? Are you confident? What do you think?
I'm leaning towards A because I think you can't become familiar with writing. Or is that just for the jury?
You're right about the reasoning, but not the answer. But you're right. The reasoning is a lay witness cannot become familiar with handwriting for the purposes of trial. So what would we go with? Think the class is rocking with C, right? Opinion testimony of a non-expert based upon a familiarity acquired in order to authenticate the signature. So it's not a familiarity they had before the trial, it's that they acquired.
Well, an expert witness could acquire it. Like an
This
expert handwriting person.
Yeah, this is admissible because this would be before, this is implying that this was before the trial. Like if I knew, like a good example of when A is the correct answer is if it's a bank teller, when it's like a bank teller recognizes the person's handwriting, therefore they can testify about it, they have personal knowledge. You can become familiar voice for the purpose of authentication. You cannot become familiar with someone's handwriting. That's just what makes the MBE so hard. Like even when you know the rule of law, sometimes the answers can become tricky. But this one just reinforces that a lay witness cannot become familiar with someone's handwriting for the purpose of trial. A lay witness cannot become familiar with a person's handwriting purpose. All right. Is that clear with everyone? Tough question. We'll pull up this next one. Keep it moving. A defendant was charged with using a forged prescription from a doctor to obtain Percodan from a drugstore on May 1. They gotta chill with those subtle references. That's weird. Is that a real drug, Percodan? Or is that a
I think that's like a combination of Percocet and codeine or something.
I have no idea what you're talking about. At trial, the drugstore owner identified the defendant as a customer, but the defendant testified that he had not been in the store. In rebuttal, the prosecutor calls 2 additional drugstore owners to testify that on May 1st, a man they identified as a defendant had presented prescriptions for the Percodan from a doctor at the drugstores. The additional drugstore's owner's testimony is admissible to prove a pertinent trait of the defendant's character and the defendant's action conformity therewith. Admissible to identify the man who presented the prescription at the original drugstore. Inadmissible because it proves specific acts rather than reputation or opinion. Inadmissible because other crimes may not be used to show propensity. Everyone who's talking about what drugs these are referencing, you need Barbara as your attorney. Take some advice. And Barbara, you've been pleading the 5th all day today. I'll call you to the stand.
No, Percodan is a real drug.
See, that's what I thought. Yeah, all right, good.
Yeah, it's oxycodone and aspirin combined. Okay.
Okay.
I thought they were making up like a name.
To quote one of my favorite professors, Professor Garrison, drugs are bad. Okay. All right, let's see. Everyone here is picking B. B, admissible to identify the man who presented the prescription at the original drugstore. I think A is definitely a bad answer, right? It's not coming in to prove conformity. Where
Yeah, I don't even know what that trait would be.
You like B, Matt?
I do.
Everyone likes B.
Damn it.
Send it. 2 classes in 1, bar prep and pharmacology. Yeah. This is the one thing everyone remembers, that Percodan is Percocet and aspirin mixed together. I hate this so much. Evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person or to show conformity therewith. However, other crimes evidence can be admissible to show identity, intent, preparation, or plan. This is a classic mimic question. The evidence the prosecutor seeks to admit is that the exact same man, the defendant, had presented on the day the exact same drug. The evidence could be admissible to prove identity, which the defendant called into question by his testimony of the person who obtained the Percodan at the drugstore. So we'll say evidence that would not be admissible to show conformity with a crime may be admissible for other reasons mimic, such as to show the identity of the Herculean dealer. What do you call them? Pharmacists. Oh, yeah. That's what you call a legal drug dealer. Pharmacists. Right? We were having, Nico and I were having a whole conversation this morning about the world and how two things in two people's hands could be judged totally differently. We were talking about John Moran and the gun, but whatever. Okay. A defendant is on trial for the theft of a used car that he took for a test drive and did not return. Oh, that's the move right there. Conversion. He was arrested in, this is not true. He was arrested in the car 2 days later. In his defense, the defendant had testified that he had no intention of keeping the car, but caught up in marital problems and simply delayed returning it. The defendant calls a witness to testify that, I should load up the poll. To testify that Andrew should load up the poll. To testify, the defendant calls a witness to testify that the defendant told him, I'm going to return this car as soon as I work things out with my wife. So a witness said that the defendant said, I'm going to return this car as soon as I work things out with my wife. Is it admissible? No, because it's a self-serving statement by an accused. No, because it's hearsay with any exception, not with an exception. Yes, as a prior consistent statement of the defendant. Yes, as a statement by the defendant of his then existing state of mind. I'm going to return this car as soon as I work things out with my wife. The more I say it, the more the correct answer sounds correct, and everyone's picking it. Oh my God. Oh, we almost had perfect uniformity. But Matt, do you agree with the majority of D?
Yeah.
Yeah, it seems like it's like if I write in a letter, I'll be in Tampa on Tuesday, or for you all, what, a month from now? Yikes. Sounds soon, a month and 2 days, a month and 3 days. So we're going with D, as in, do you want to go to the mall today? No, finish spelling. Federal rule of evidence allows a hearsay exception for then existing mental, emotional, or physical condition. Statements of the present state of mind offered to prove the state of mind are admissible under this rule. The defendant states an out-of-court statement offered to prove asserted that he did not have intent to steal a car. However, the statement meets 803 because it reflects his lack of motive or intent at the crime. So this is then existing mental, emotion, or physical condition. Saying or writing, I intend to do something on a certain date is an exception to hearsay as a then existing mental, how do they call it? Then existing mental, emotional, or physical condition. Mental, physical, or emotional condition. All right. Keep it going, stop sharing, load up a new poll. It's like clockwork, like Yosemite, Old Faithful. I don't want to do a car crash. Ooh, let's do this one, stealing money. Still gotten gains. A plaintiff sued a defendant for libel. After the plaintiff testified, the defendant wrote to the plaintiff's employer that the plaintiff was a thief. The defendant offers evidence that the plaintiff once stole money from a former employer. The evidence of the plaintiff's prior theft is admissible as substance evidence to prove that the plaintiff is a thief. Admissible, but only to impeach the plaintiff's credibility. Inadmissible because character may be shown by specific instances of conduct. Inadmissible because such evidence is more unfairly prejudicial than probative. Tough one. I kind of want to talk this one out. Let's see. Omar getting those laps in. That's what's up.
So I
know you know the answer, Matt, to be honest.
are we waiting for the poll to be done?
I know that you know that I know that you know that we know the answer. Let's see if one of our contestants knows. We have 61% participation. Can I get a hallelujah? This is good. Someone picked D. No one's picked D yet. No, don't pick D. It's not D. But just D's looking lonely. All right, perfect. I don't know why I made 72 like my threshold, but that is what it is. So A is looking like the number one answer. I tend to agree with A. Matt, you agree with A?
I put A.
I think, yeah, A, at first B was winning, but A came out strong in the end. Why? Because this is exactly what we talk about, where
Defamation's a unique case.
character's at issue, right? He's a thief. This
Yeah.
could all, there's another question that says to show liability and damages, and it's true, damages too. Like, you're a thief. It can be brought in for all the above. You once stole money, therefore you're a thief. And why is defamation liable a special case? Because truth is an absolute defense to defamation. Thief, then they didn't defame you. There was no libel. A, as in awesome. See, the plaintiff's character trait for thievery is essential. So evidence that the plaintiff stole money from a former employer in prior cases thus admissible to prove the plaintiff is a thief. So it is admissible to present evidence that someone was a thief if they are, if it is a defamation case because character is at issue. Does that make sense? It's admissible to present evidence that someone was a thief if it's a defamation case because character is at issue. That's the key.
Yeah, the main thing is that you can use character evidence when character is at issue, for example, defamation.
You can use character.
Because I think people see character evidence and they go, oh, that's automatically wrong.
Especially if it's civil.
Yeah.
Because in criminal, it could be right if they first open the door. And as we said today, we're really fond of door openers. Holding open doors is very amazing.
Except the clerks. Oh,
Clerk is amazing too. I have love for clerks. I spread love. Brooklyn. In a federal diversity action by plaintiff against a defendant on an insurance claim, a question arose whether the court should apply a presumption that when both husband and wife were killed in an accident, the husband died last. Whether this presumption should be applied is to be determined according to traditional common law, federal statutory law, the law of the state whose substantive law is applied, the federal common law. Key thing here is diversity. If this was a federal claim, federal question, it could be different, but this is diversity. Everyone's going with C on this one for the most part. I agree. C? You agree, Matt?
I put C.
C's get degrees. C is correct. In civil actions proceeding, whether presumption should be applied is determined in accordance with the state law whose substantive law is applied to the case. So whether
Presumption
is applied is determined by the law of the state in which the substantive law. Cool. All right, another poll. There it goes. All right, air pollution. A plaintiff sued an industrial facility in her neighborhood for inquiries to her health caused by air pollution. At trial, the plaintiff was asked questions on direct examination about the days in which she had observed large amounts of dust in the air and how long the condition had lasted. She testified that she cannot remember the specific times but that she maintained a diary in which she had accurately recorded this information on a daily basis. When her attorney sought to refresh her recollection with her diary, she could still not remember. The plaintiff's attorney seeks to have the information in the diary admitted at trial. Is the information admissible? No, because reviewing it did not refresh the plaintiff's recollection. No, unless it's offered by the defendant. Yes, and the plaintiff should be allowed the option of reading it into evidence or having a diary received as an exhibit. Yes, and the plaintiff should be allowed to read the diary into evidence.
It sounds like something we did today.
Yeah, exactly. Yeah, exactly. It sounds like something we said today, and Matt and I both agreed. We came to an agreement. And my understanding is specifically in this question, literally. Everything I know about this law is based on this question. Matt probably has read like 5,000 documents. Ooh. I'm getting to know that people don't trust me. It's fine. Oh, you trust me? No more answers? 68% participation? All right. Can't force people to participate. So, all right, Matt, why don't you walk us through how you would answer this one based on what you know? And I'll tell you what I would know based on what I did now.
Yeah, so this is a recorded recollection hearsay exception. So they tried refreshing, it failed, but then she like affirmed on the stand that this was accurate. Then the plaintiff seeks to have the information in the diary admitted. And the plaintiff can't introduce it as an exhibit, but they can read it into evidence. So it'd be D.
I agree with you. That's what we said at the beginning of class. Like, okay, it's a bowl of spaghetti. Oh yeah, I remember back in 1947, I was selling meatballs, but they were actually Irkadons or whatever, right? Like, yeah, the spaghetti refresh your memory. That's okay. You're allowed to refresh your memory. But as we said at the beginning of class, or at least I said, and my memory has failed me, this is the correct answer, that it's not going to be received as an exhibit, no. But if the plaintiff wants to read it into evidence, they will read it. I'm going with D based on Matt and I agreeing, but I know only 3 others in the class agree with us. But it is right. And I'm not a genius. I literally did this question like an hour ago. But this is where I got the beginning of class when I wasn't on camera. This is where I was coming from. Like, from this question, let's see what it says. The information in the diary is admissible as a past recollection recorded because the plaintiff made a record based on firsthand knowledge when the matter was fresh in her memory, which accurately reflected her knowledge, and she has insufficient recollection as at trial. Oh, that's the difference here, that this is a past recollection recorded. This isn't just used to refresh your memory.
So they tried that and it failed.
Right, okay, good job. So what I said wasn't true, that you could read it into evidence always. It's just that here, because it established as a past recollection recorded, that's why this is admissible and can be read into evidence. Interesting. So if we leave the extended definition or explanation, the federal rules of evidence define hearsay as a statement other than one made by the declarant while testifying the current trial or hearing offered into evidence to prove the truth of the matter asserted. When a witness on the stand has trouble remembering an event, he may be given a writing picture or some other document to aid his recollection, the bowl of spaghetti. Nearly all courts permit any item to be shown to a witness while on the stand to refresh the recollection. Definitely. The rules requiring authentication do not apply to the item being used to refresh the witness's recollection. It does not need to even be admissible. However, if a witness's memory cannot be revived, a party may wish to introduce a memorandum that the witness made or adopted at the time of the event. So this is why this is the answer to this question. These are 2 different pieces. Then they gave him a memorandum that they made. Use of this writing to prove the facts obtained therein raised the hearsay problem. However, if a proper foundation can be laid And the foundation for laying in a recorded recollection is that they have no memory and it's accurate. So D is correct. Under FERE 035, an out-of-court statement may be admissible as a recorded recollection exception to the hearsay rule when the witness made a record based on firsthand knowledge, when the matter was fresh in the witness's memory, which accurately reflected the witness's knowledge, and the witness has insufficient recollection at trial. A qualifying recorded recollection may be read into evidence, but not offered as exhibit unless by the opposing party. In this case, the information about the plaintiff's diary meets all the elements of a recorded recollection, therefore it may be read into evidence. So again, I'm always, I even said this to Nico at the beginning of class today. I was like, hey, we're confused about a couple. Confusion is on the path to clarity. And I've just arrived at some clarity, and hopefully I can share that with the entire class. That if it is just used to refresh your memory, it's not being read into evidence. It's not coming in at all. It's hearsay, basically. Like, that's just something that the other party can look at if they want to, but it's not going to be read into evidence. The only reason that this was read into evidence is because it separately was a foundation was established that it was a recorded recollection. So that's why it was read into evidence. So the key that we can take away here are a recorded recollection with proper foundation used to refresh memory on the stand can be read into evidence if the party requests, right? It has to be a recorded recollection with the proper foundation. If it was just a bowl of spaghetti, we're clearly not going to read that bowl of spaghetti into the record. Is that proper and everyone agrees with that? The reason why this one came in here is because it was a recorded recollection. If you go back to the fact pattern, it says they were asked questions. She testified she cannot remember. They sought to refresh her recollection with her diary. She could not remember. Is this information admissible? And does it ever say that the diary was accurate when she made it? She maintained a diary in which she had accurately recorded this information on a daily basis, and now she cannot remember. Those are the elements right there of a recorded recollection, that it was accurate when it was made, accurately when it was made, and that now she cannot remember. That elevates this from just something, a refreshed recollection, to a recorded recollection. And because it's a recorded recollection, it can be read into evidence. Everyone cool with that? Amy's saying because when someone's been refreshed, they don't use a document anymore, they just testify, so it doesn't come in. Exactly. If it's just refresher, we're not going to read it in, we're not going to allow it in. But if it's a recorded recollection, it will indeed be read in. And here, as Matt was able to deduce, this had the proper foundation for recorded recollection. So great job. I don't really like that question. Let's try this one. Oh, no clear memory, right? It was accurate when made. She clearly has no clear memory. It's got to be a recorded recollection. Like, without even doing the question, we can probably answer that. A plaintiff sued defendant for wrongful death arising out of a traffic collision because the plaintiff's decedent and the defendant, between the decedent and defendant. At trial, the investigating police officer authenticated tape recording of her shift-ending dictation of comments used in preparing the written report of her factual findings. She testified that the tape recording was accurate when made and that she currently has no clear memory of the details of the investigation. Is it admissible as evidence? This is like a sign to reinforce this. Yes, under the recorded recollection. Yes, under business records. I don't like that. No, because it's hearsay and is a police report being offered against a death and wrongful death case. No, because of the police report is the best evidence. You agree with me, Matt, here? This is a recorded recollection?
Yeah, they're trying to trick you with C because that exception only really applies in criminal cases.
They try to trick me with C real quickly. The recording satisfies a recorded recollection exemption to hearsay rule because the witness's memory cannot be revived. It was made when the matter was fresh in her mind and it was accurate. So we'll reinforce that on our sheet. Recorded recollection, accurate when made, currently no memory of what was recorded. Right? Because it had those elements, we're able to do a recorded recollection exception to the hearsay rule. All right, let's bring our old friend, the poll, back. The poll. Double. That's a Toy Story reference. I'm trying to do the claw. The claw. At defendant's trial for a gang-related murder, next, the prosecution introduced as former testimony a statement by a gang member who testified against the defendant at a preliminary hearing and has now invoked his privilege against self-incrimination. If the defendant now seeks to impeach the credibility of the gang member, which of the following is the court most likely to admit? Evidence that the gang member has 3 misdemeanor convictions for assault, testimony by a psychologist that persons with the gang member's background have a tendency to fabricate, testimony by a witness that at the time the gang member testified, the gang member was challenging defendant's leadership role in the gang, and testimony by a witness that the gang member is a cocaine dealer. We're all going to get these questions right on test day 2, all my students, because I preach this, but they love testing this. If it smells like this, it probably is this, right? And what I mean by that is exactly what most people are guessing. Not guessing, I don't want to use that word, are picking, choosing, right? C, because what does C implicate? Bias. And that's what I'm saying. If it smells like bias, it's probably bias. If it's some reason where it's like, wait a minute, this is a reason why the person is giving unreliable testimony, we're probably going to let it in. So you agree with us, Matt, C?
Yeah, I picked C. Because it shows he has an ulterior motive.
Yeah. He was challenging his role for the gang. So evidence of bias is admissible to impeach, such as evidence that witness was challenging for leadership of gang and is now
like what's going on in Russia right now.
testifying against gang.
Or not anymore, but yesterday.
Honestly, I saw some little thing. I just like, all I do is teach for the bar, or maybe some math or some whatever, run my business. I have no idea what's going on in Russia or the bottom of the ocean or any of that stuff. I just get little pieces. And I'm happier that way. But why? What's going on in Russia? Is the war over or not quite?
No. No, there was some stuff. Like some mercenaries marched to Moscow, but then they decided not to.
Is it almost over?
No.
Let's see.
Probably not.
Okay. Wait, oh shoot. I gotta launch a new poll, everyone. This will probably be the last poll we do today, and then we'll finish up just talking it out for time's sake. But everyone,
I think we've gotten everything right so far.
oh my God, you just
sorry, I just crushed it.
Why would you do that? I'm just kidding. But
now it's just like upstate, like there's a lot more pressure on the next one.
No, I mean, bro, like it's been done has been done. Now everyone can see the answer. All right, just to be honest, like our chances of getting this one right after that are very low because, we know. So let's just do our best. Forces working against us. A woman sued her friend for injuries she received as a passenger in her friend's car. On direct examination, the woman testified that the friend had been speeding and ran a red light. On cross-examination, the woman was asked whether she was under the influence of drugs at the time of the accident. The woman invoked a privilege against self-incrimination. How should the court treat the woman's claim of privilege? Deny it because the woman waived the privilege by voluntarily testifying. Deny it because evidence of the woman's intoxication is essential to assessing the accuracy of her observations. Uphold it because the privilege applies in both civil and criminal cases. Uphold it because the woman's credibility cannot be impeached by a crime for which she has not been convicted. I mean, I know an answer I would pick here, but now I'm just nervous that whatever I picked, I picked.
Yeah, I've seen this question before, like in the past few days.
All right, good.
So I'll be fine.
I'll tell you what I think it is, and you tell me if I'm correct, and then we'll have made it past the Matt Beckerman cursive 1158, which only lasts for 3 minutes, so we should be fine. Ooh, we have a split too. Sheesh.
So I mean, I put C.
All right, I'm putting C too.
Yeah.
I like how you just jumped right to it.
There's too much tension in the air. Yeah, so you have the right against self-incrimination in all cases because it's guaranteed by the Constitution. But in civil cases, they can hold it against you. Like, why wouldn't he talk about that? That's suspicious. In criminal cases, they can't hold it against you.
That's exactly the truth. You can raise the, I plead the fifth, like Dave Chappelle used to do in a Chappelle show, and you can plead it in civil or criminal, but in civil, they're allowed to make a presumption. Like, yo, this dude pled the fifth, you know, like he pled the fifth for. In criminal, you can't make any presumption. So I'm rocking with C. Why'd you say oof, Amy?
I went with B because I didn't think that it would expose her to criminal liability or anything because she was a passenger.
I think you can use it no matter what.
Yeah,
you don't have to be like rational about it.
It would subject her to criminal liability because she would be admitting that she was drunk driving, right? Because wasn't that what it was saying?
Yeah.
But
I think I don't think that we need to like.
No, but even being under the influence of drugs is in.
Yeah.
So you're not
even for stuff that's like embarrassing but not criminal. I think you could still use the fifth, I believe.
Yeah. So let's just put for this: the fifth may be invoked in civil or criminal, but in civil, an inference may be made.
Yeah.
All right. Let's do one more poll. I feel like everyone likes like when the band comes out for one more.
Yeah, but we have to get it right. I'm just kidding.
Oh man. But you know what? You're so confident in your abilities. I like that. All right. Wait, no, I messed up this poll. Sorry, everyone. Give me a second to launch one more poll. Would you go to a submarine to the bottom of the ocean right now? Are you that confident?
I would go in the one that James Cameron uses. I wouldn't go in a different kind.
That's the guy who made Avatar and like.
Well, he also made Titanic, yeah.
Oh, Titanic. Oh, yeah.
And Terminator.
I like Titanic. That's a good movie. All right, here we go. Everyone can answer. A plaintiff sued a department store for injuries she sustained when she slipped and fell in the store. At trial, the plaintiff proposes to testify that when the store manager rushed to the scene, he said to the plaintiff, "I'm so sorry about the water on the floor there, but don't worry, the store will pay for the ambulance and your hospital bill." The store attorney objects. How should the court rule on the admissibility of the store manager's testimony? Testimony is admissible in its entirety as a statement of opposing party. The testimony about the water is admissible as a statement of opposing party, but the rest of the testimony is admissible as an offer to pay medical expenses. The testimony is admissible in its entirety because it's hearsay not with any exception. The testimony is inadmissible in its entirety because the manager's statement in the context of an offer to pay medical expenses. See if we can get some answers on this one. It's a tough question. %58 participation. Okay, we got 75% participation. Everyone's rocking with B for the most part. You agree with that, Matt?
Yeah, I put B. It's a half and half.
It's a half and half. Can you explain to me honestly these half and half? Is it always half and half, or when is it not half and half? Are there any circumstances that you remember?
Well, what do you mean half? Like it just depends. Like you can introduce like if there's like an entire.
What if it's an offer to settle and not an offer to what was this? An offer to.
An offer to settle isn't. I don't think that's inadmissible. It's the settlement of, like negotiations that's inadmissible.
Right. So the whole thing would be inadmissible because all part of the offer to settle.
Well, I think if someone says like, "Will you settle with me?" and the other person says no, I'm not sure if that's inadmissible right there.
Interesting. And Natasha sent us something that I was going to read, but then she put a question mark after it.
Yeah, so, like the part here it says, I'm so sorry about the water on the floor, but don't worry, the store will pay for the ambulance and your hospital bill. Like you can carve out the second half because that clearly relates to medical expenses, which is not allowed. And I'm
Yeah.
so sorry about the water. That is not about medical expenses or settlement negotiations or like fixing something later or any exception.
I love what Natasha wrote.
You can chop things up.
I love what Natasha wrote. Collateral admissions, a statement of fault made in conjunction with a statement regarding the possession of liability insurance is admissible. The statements can be bifurcated, split. So the admission of fault, while the statement regarding possessing insurance is inadmissible. The general rule offers if a medical, hospital, or similar expenses resulting from an injury are not admissible to prove liability for that injury. All right. Luis is saying, what about the playground rule? I don't know.
I don't know what that is. Is that a joke or is that like a real rule?
Luis, what playground rule are you talking about? All right, well, I don't know either, but let's see what the takeaway here is. You know what I'm gonna do, Natasha? I'm gonna just post what you said, because I think you explained it perfectly, the collateral admissions. All right, let's go to the very next question. And that's right, we're playing another song. One more, yeah. All right, one more poll. A plaintiff sought a products liability action against the defendant. The manufacturer of a sport utility vehicle that the plaintiff's decedent was driving when she was fatally injured in a rollover accident. The plaintiff claims that the design defect in the vehicle caused it to roll over. The defendant claims that the cause of the accident was the decedent's driving at excessive speeds during an ice storm. Eyewitnesses to the accident have given contradictory estimates about the vehicle's speed just before the rollover. It's also disputed whether the decedent was killed instantly. Which of the following items of offered evidence is the court most likely to admit? A videotape offered by the defendant of a test conducted by the defendant showing that a sport utility vehicle of the same model the decedent was driving did not roll over when driven by a professional driver on a dry test track at the top speed testified to by the eyewitness. A videotape offered by the plaintiff of a television news program about sports utility vehicles that include footage of accident scenes in which the vehicles have rolled over. Evidence offered by the defendant that the decedent had received 2 citations for speeding in the previous 3 years. Photographs taken at the accident scene and during the autopsy that would help the plaintiff's medical expert explain to the jury why she concluded that the decedent did not die instantly. As I read them, the right answer just like jumped off the paper. We have 33% participation. Oh no, participation is dwindling. All right, I think most people agree with D. D's got to be the correct answer here, right? Because D's a photograph from the accident scene. All these things are right.
Like C is like not enough for habit. A is just not at all related, and then B it doesn't seem very helpful.
Yeah. So in general, I'd just say properly authenticated, which is easy. Photographs from the crime scene are admissible. They're relevant. I'll spell that wrong. Right. When I say which is easy, it's very easy to authenticate a photograph. I think in 2027, it's going to be more difficult because of deep fakes and things like that. So, yeah, let's just do one more poll. I just want to give the people what they want. That's my biggest problem in life. Okay, I know that people want to do another poll. So we'll do another poll. Under the rule allowing exclusion of relevant evidence because its probative value is substantially outweighed by other considerations, which of the following is not to be considered? The jury may be confused about the appropriate application of the evidence to the issues of the case. The evidence is likely to arouse unfair prejudice on the part of the jury. The opponent is surprised by the evidence and not fairly prepared to meet it. And the trial will be extended and made cumbersome by hearing evidence of relatively trivial consequence. So we like confusion, we like unfair prejudice, and we like cumbersomeness. We don't like surprise. So everyone in
Yeah.
the class, we have unanimous decision. 12 angry men have all picked
Voted.
C. Yep, so confusion, prejudice, and cumbersome are going to be reasons for prejudicial. So we could say prejudice equals what did they say? Confusing,
Not a 403 balancing test factor.
confusing, unfair prejudice, or cumbersome. So confusing, unfair prejudice, or cumbersome. And it's not prejudice, it's a failed balancing test. Okay, but surprise is not an element, just so we know. I still want to know what the playground rule is by Luis. Or is that a joke? If it's a joke, it's hilarious.
No, no, not a joke. It basically just states that while you do something, you have an incident, and you only say I'm sorry, that can't be used against you. If you say anything else other than I'm sorry, that second part can be used against you.
Is that true? I've never heard that rule.
Yeah, I'm not sure either.
Yeah, it's in one of the questionnaires from the multiple choice. I think from July 2022, if I'm not mistaken.
From Florida or MBE?
Florida. It's from Florida. I'm sorry. Yeah.
Yeah, this is a federal course, so let's not talk about things from the state, but you might be right. Maybe that's why Matt's never heard of it. Maybe that's a Florida rule. I'll look into that. All right, let's do another poll. But I appreciate you, Luis, because we want to talk about things. But if Matt and I can't substantiate it, it probably doesn't apply to federal law. So or maybe it does, but it's just not that important on the test because Matt got such a high score and he never knew it. That's kind of
I didn't need to know the playground rule.
Yeah, that's kind of how I feel. If Matt didn't need to know the playground rule, then none of y'all need to know it that well. All right, let's try this one. A defendant was charged with perjury for having falsely testified in an earlier civil case that he knew nothing about business fraud. In the perjury trial, the defendant again testified that he knew nothing about the business fraud. In rebuttal, the prosecutors called a witness to testify that after the civil trial was over, the defendant admitted to the witness privately that he knew about the fraud. Is the witness's testimony in the perjury trial admissible? Yes, but only to impeach the defendant's testimony. Yes, both to impeach the defendant's testimony and as substance evidence of the perjury. No, because it's hearsay now with an exception. No, because it relates to the business fraud and not to the commission of the perjury. I might need you feel confident in this one, Matt?
Oh, sorry, I was muted. I put B
Yeah, that's what the class is picking.
because I mean it's clearly inconsistent and also is like an adverse party, admission.
That he admitted it, right? It's an adverse party admission, right? That's what's going to bring in substantively. Is that's an admission. At first, I was thinking, hey, it's only to impeach, but you know it is admission, right? Does anyone want to rebut that and think it's A, that voted A? Or do we think it comes in substantively as admission? Confidence levels high? Nice. The statement is admission. What's up?
I had a lot riding on that.
You don't have anything riding on this, man. Don't worry. You have nothing riding on this here.
No, I've never.
I think somehow my team already named Robert as tutor of the month. And I'm like, the month's not even over yet. Like, how did I not? Alexis, she really likes Robert, I guess. All right. So what did we say here that this is an admission, right? Party opponent admissions can be admissible as impeachment and substantive evidence as actually an exemption, right? In federal law, exemption to the hearsay rule.
Yes, it is an exemption.
Yeah. Of course, it's gotta be different in Florida. In Florida. All right. I know I promised that there would be no more polls, but I got one more poll. So I don't want to do this one. I already did that one earlier today. Let's try. Done with this one. The defendant charged with armed robbery of a store denied that he was the person who had robbed the store. In presenting the state's case, the prosecutor seeks to introduce evidence that the defendant has robbed 2 other stores in the past year. This guy's catching licks. The evidence is admissible to prove a pertinent trait in the defendant's character and the defense action to conformity therewith. I'm taking this off. Please don't ever pick that. Admissible to prove the defendant's intent and identity. Inadmissible because character must be proved by reputation or opinion and may not be proved by specific acts. Inadmissible because its probative value is substantially outweighed by the danger of unfair prejudice.
Is there a poll?
Yeah, there is a poll, but I don't know if I'm loving it. The responses that the polls are giving me. Okay, now that we're having a comeback, potentially, we have 54% participation. This is a good argument. I'm happy that I kept the polls going. All right, one more vote. One more vote. Nice, we got 72% participation, and it ended up in an even split. Wow, I'll be honest, B's were killing it off the gate. It's like a horse race, and D's came in. I wish you got to see it from my angle. It's so much more interesting. So D over B or B over D. Matt, maybe go ahead. You put D as in doctor.
D as in danger of unfair prejudice, which I think this is.
Yeah, I think it's D. I just don't think that it's enough. What intent and identity, like just 2 other stores. Like if it would have been like the same store in the same manner, like, you know, you would have done it with like off of 10 Percodons or whatever. But
like he's saying he didn't rob the store. Showing that he robbed other stores doesn't show intent or identity.
And then why not C?
Because they're not even getting a character. They're trying to show that he robbed the store.
Anyone agree that's B or think it's B or C? Or we think Matt is pretty much correct, it's D? Nice. D is correct. Evident defendant's prior bad acts, 2 past robberies is inadmissible because it's attempting to establish the defendant's bad character. The probative value of this evidence is substantially outweighed by the danger of unfair prejudice. C is incorrect because admitting the prior robberies as character evidence would be improper. There's no need to determine the correct method of introducing the evidence itself. Nice, excellent answer. So we cannot bring in evidence of 2 past robberies to show intent or identity. For a current robbery because the probative is outweighed by the prejudicial value. And there is no common scheme or plan or identifiable feature, right?
Yeah, like if it was some evidence showing that, like, oh, I really want to rob, I don't know. I can't even think of something that would be to show intent, but like that doesn't really show intent.
Excellent.
That would that's just character evidence.
And honestly, just because I'm so pleased with the participation, I'm gonna load up another poll. I was gonna just have Matt and I fire through them, but 72%.
How many are?
Not that many. Just enough. I'm just bantering with Matt. This is just for my comic relief. Don't take me too seriously. All right. A plaintiff sued a defendant for injuries sustained in an automobile collision. During the plaintiff's hospital stay, a staff physician examined the plaintiff's x-rays and said to the plaintiff, "You have a fracture of 2 vertebrae, C4 and C5. Yikes, that's Ryan Garcia when he fought Gervonta Davis. An intern who was accompanied the doctor on rounds, immediately wrote the diagnosis on the plaintiff's hospital record. At trial, the hospital records custodian testifies that the plaintiff's hospital record was made and kept in the ordinary course of the hospital's business. The entry reporting the doctor's diagnosis is inadmissible because no foundation has been laid for the doctor's competence as an expert. Inadmissible because the doctor's opinion is based upon data that are not in evidence. Admissible as a statement of then existing physical condition. Admissible as a record of regularly conducted business activity. Wow, everyone picked D. Holy bananas. The answer is D, right, Matt? I love being able to be like, right, Matt? Having you here is awesome. For the record, we did get 25 out of 25 on Torch too. It's not like we're incapable on our own. All right. So hospital records are generally admissible as business records of regularly recorded activity if they relate to medical diagnosis or treatment of the patient. So let's just say hospital records related to the treatment are generally admissible as regularly recorded business activities. Okay. That's it, 25 or 25, look at us. All right, let's go over all the ones we got wrong. Oh, there's none to go over, we're so amazing. No, okay. Does anyone have any questions for me or Matt or for any of your classmates? I'll make sure to organize those notes we took from class so they're a little bit more clear. And yeah, evidence is tough, but if you just go over it methodically, you can get better. And as you see, Matt is really everything we claim him to be. So if you want to work with him, call us up and you can sign up. And thank you all so much.